All right, welcome back to the Law and Crime Network. My name is Bob Bianchi. I'll be taking it with you till 3 o'clock today. Guys, you know if you're on this network, it is a Dan Abrams production. Multiple trials of the most fascinating sort, gavel-to-gavel coverage, 24/7 here at the network. It is such an honor. I'm so proud to be part of the team here. I'm going to jump right to it, guys, because we got a fascinating case. I've been really looking forward to this one from the day that I read about it a long time ago. But first, I want to bring in my guest because the producers are nice enough to say, Bob, just jump right into it because opening statements are about to begin. Kirk Burkhalter is a professor at New York Law, 20 years experience at the NYPD, had graduated there as a first grade detective, has done long-term investigations, organized crime and criminal enterprises as well as terrorism. I've had him on the show many times. He is an awesome guest. I'm so glad to have him here. Welcome to the show, Professor.
Always a pleasure, Bob.
Okay, and we're going to have Jean Rossi a little bit later on. So, Professor, I want to go to this cop shooting case, and this is the Amber Guyger case. She's 31 years old. She was a 4-year veteran of the police department, and boy, there's nobody better than somebody like you to be here to break this case down because it is a police case. She was originally charged with manslaughter. This is out of Texas. Now, I mentioned this. You see a picture over there, and it always gets me, Professor, when you see a police officer in orange. It's really a stark contrast from where they were. She was wearing her uniform supposedly when the event occurred. So what is this case about, Professor? So this case is about a woman who got done with a 15-hour shift on the police department, and she was going home to her apartment. Now, she claims that she thought she was at her apartment, and she tried to gain entry into the apartment, and she saw a figure that was there, and she thought that she was being burglarized. She was in fear of her life. She pulled her service weapon out because she was still in uniform, and she shot and killed the man. So originally, this case was charged as a manslaughter. It then got upgraded in the grand jury to a murder case. So look, there's so much here, and here's a spoiler alert for our audience, for our true crime aficionados, those law students that watch us, lawyers who are looking to better themselves on trial work. Let me tell you how to prepare a trial notebook. The first thing I would instruct my prosecutors, and soon we're going to have Jean Rossi on, and he's trained so many people, I'm sure he'll have the same opinion, is you put the indictment as the first thing in the trial notebook, and then the jury instructions. The jury instructions are the thing that are read at the end of the case, that the jury will be instructed by the judge as to what the law is. And so many times, I've often talked about this on the network, people have a gut reaction to a case and they have a feeling about a case. But you know as a trial lawyer that all those gut instincts and feelings you have mean nothing if you don't know what the jury is actually read at the end of the case as to what the law is. This case, in my opinion, is going to come down to the legal issues, not the factual issues. Professor, I'll just throw it to you real quick. Do you have any general thoughts about the case from any standpoint that you have right now?
Well, I think what you just said is just incredibly insightful. I think this case is going to come down to the jury, what they believe, because she's charged with intending to cause serious bodily injury and causing death. However, her defense is going to be mistake of fact. And that is a question for the jury, whether that mistake was reasonable or it was unreasonable.
Okay, so you understand what the professor is saying, and we're going to do a little bit more. You see they're live in court and there's some motions we're going to throw to it in a second, is that there are various defenses in the law. It says even if you did it, for example, self-defense is an affirmative defense, we call it. And what the professor just referred to, which is really important here, is a mistake of fact. Whether the mistake that she made believing she was in her apartment is an affirmative defense for the actions that she took. Now, we'll talk more about that a little bit later. Let's go to court on some of these legal motions just before openings. Okay, and as you know, that's the reality of the court world. You're there 1 minute, not hurry up and wait, as we used to like to say, or still do say, actually now in my criminal defense practice. So, Professor, I want to start with, before we get to what the defenses are, as to what the charges are. Now, the charge that she's charged with are upgraded from manslaughter to murder. Right. And so let's make some distinctions for our audience about what these things mean. So murder in Texas is kind of confusing because they don't have like first degree or second degree. They kind of lump it all into one thing. But one part of it, and I have the definitions in front of me here, is the intentional killing of another person. And this is what the jury will be read, and this is why it's important. A person acts intentionally, ladies and gentlemen, the jury with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious, objective, or desire to engage in the conduct or cause the result. So in other words, this is usually typically left for people who are, I got a gun, I'm mad at you, I'm going to shoot you, I'm intentionally and consciously doing it, and I intend to cause that result death. It could be a tough road for the prosecutor here in a case like this.
Oh, absolutely. At first blush, I thought, my goodness, this is going to be so difficult for the prosecutor to prove. However, that intent doesn't have to be formulated over a long period of time. It can be formulated darn near instantaneously, right? So you attack me at this moment and I step back and I pull a knife from my pocket and I defend myself. I have acted intentionally, voluntarily, not only voluntarily, but I have had that state of mind to do so. So here, that's what is going on. I don't want our viewers to think that the prosecution has to prove that this was in any way premeditated or she thought about it. It was just that this was an instantaneous, intentional act.
Right. Now, Professor, I'm being told by the producers, as you gave that excellent definition there, that there was a motion for a mistrial made by the defense for a violation of the gag order. The judge is taking a 10-minute break, so it gives us a perfect opportunity to go through what we call in the law the states of mind that are required. Because, you know, Professor, what I've noticed over a career of 30 years, half of it prosecuting and half of it as a defense lawyer, and now as a defense lawyer, is that cases, more and more cases are coming up that I would call, or would traditionally be considered accidents, you know, in the past, but are now being criminalized. And there's a big thing in the criminal justice reform process that, why are we criminalizing life? I'll tell you a case I recently had. A guy had a heart attack in his car, driving his car, and injured another person, you know, because he was having that event. Was charged with assault by auto. That would never have happened 30 years ago.
Absolutely. I mean, there's so many hoops you have to jump through. You talked about these states of mind. So in the hierarchy, starting with the highest, intentional, knowingly, and then recklessly and negligently. So,
right. So intentionally would be, that's my intention, that's what I want to do. Knowingly, you just mentioned it, you hit him way off, you're right, that's why you're the professor. A person that's a second stage acts knowingly with knowledge with respect to the nature of his conduct or to the circumstances surrounding his conduct when he is aware of the nature of the conduct and that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause that result. So it doesn't necessarily mean that you want that the result to happen, but this is kind of like the example of like when you shoot a gun into a crowd. You may not want to kill somebody, but it could be reasonably certain that that is going to be the result. You want to talk about that?
Sure. And most commonly we see that particular culpable mental state attached to crimes involving possession of some form of contraband or narcotics. It's usually knowingly possessed XYZ. Violent crimes, homicides, assaults, usually there has to be folks need to be more blameworthy, and that's the way we describe it. And that's why the culpable state of intentionally or purposely is attached to it.
Okay, so, and you know, these definitions really aren't foreign to us. Every state basically has it. It's just the way they put it in the rubric there in Texas. So either one of those could be first or second degree murder cases. Now, another state of mind, if you will, or a place where you could be culpable criminally is if you act recklessly. So we've done intentionally, knowingly, and now recklessly. And recklessly is defined, ladies and gentlemen of the jury, a person is reckless with respect to circumstances surrounding his conduct or the result of his conduct when he is aware of, but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree, here's the key, that its disregard is a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. So in other words, one thing I want to really emphasize with that is that they're saying that they're aware of it and that it's a gross deviation from a reasonable person. But I think there's a lot of wiggle room for a jury, doesn't it? Reasonable person, aware of, and well, you know, there's a lot there for the jury to gnaw on.
Absolutely, and this is probably in operation one of the more difficult standards to prove. For instance, depraved and indifference homicide. So you have this awareness factor. You have to show the person is aware and that they absolutely disregard it. So it's akin to going out during lunch hour in a crowded metropolitan area and taking a machine gun and just spraying it aimlessly, not necessarily intending to hurt someone, but you are aware that you are likely to cause serious bodily harm.
Okay, and the other category they have in Texas is criminal negligent homicide. Now, the reason that these are all important is they may be considered what we call lesser included offenses at the end of the trial. Even though she's charged with murder today, the judge may decide, I'm charging these other lesser offenses because a jury could reasonably come to that conclusion, and I don't want to pigeonhole them between a straight out not guilty or guilty on one versus a dismissal or rather guilty on the whole enchilada. A lot of times the courts require that they give the jurors many options. So as you can see there, folks, whether it's intentional or with knowledge or reckless or negligent, depends on some very heavy definitions that the jury will come, and it's very important to the defendant because intentional knowledge, that's bad. Reckless and negligent, much better for the defense. But we haven't even gotten to the actual what we call affirmative defenses in this case. I love this case. I'm so glad we're doing it because we get to do an education, go back to law school with the professor here, but it makes a huge difference in this trial. The Law and Crime Network, gavel to gavel coverage. We're taking a break. We'll be right back.
This week on the Law and Crime Network, the high-profile murder trial of Dallas police officer Amber Guyger, accused of shooting and killing Botham Jean. She went home, opened the door, saw John, and opened fire thinking he was an intruder. It turns out she was in the wrong apartment. Also, the Florida trial of two defendants accused of brutally murdering law professor Dan Markle. The nation's biggest criminal cases are live and unfiltered on the Law and Crime Network.
All right, crew, let's get started. Sure.
Don't ignore the law. You must call 811 at least 2 to 3 days before any digging project so you can avoid hitting our essential buried utilities. For digging projects big or small, make the call to 811.
How I define making? In the broadest possible terms, it is making something extant in the world that didn't exist. Everybody who's ever made anything is bringing something into fruition for a reason, and that act in and of itself makes us stewards of our culture. It's something that we're talking about. It's a response. Actually, it's telling a story. That's really what it is. And I include everything that could be made: painting, sculpture, welding, all of that.
Yellow is positive.
When a kid gets their hands on the world and learns that they can make their fantasy play, that they can make their reality, that's power. And as far as I'm concerned, everyone should feel that kind of power. There we go. If there's something that interests you to bring into the world, that's fantastic. Go figure out how to do it. Go tell your own story. There it is. And so I want to know why you make. Let's go.
Share your own Why I Make story today. Visit whyimake.org.
We believe in patriotism. We believe in our nation's youth. We believe veterans earn their benefits through their service to our nation. We believe in a strong national security. We believe in our country. For 100 years, veterans have been impacting our nation through the American Legion, and we believe it makes a difference. If you believe, learn more at legion.org/webelieve.
Anyone can fall victim to moving fraud. Know your rights and responsibilities.
We had really signed off on a price, and that was about it.
Without a signed written estimate, movers may try to charge more.
They were charging us now $2,000 instead of the agreed upon $900.
And may hold your items hostage until you pay.
Not only had they roughly handled or mishandled, it seemed like they had purposely destroyed things.
Visit protectyourmove.gov to download a free moving fraud prevention guide. Search for registered movers and view their complaint histories. Move with confidence.
All right, welcome back. Amber Guyger trial, former police officer on trial for her life for murder. Folks, this is such an odd case where there she is as a police officer. She got done with a 15-hour shift, went to her apartment building, went to the 3rd floor as opposed to where she lived on the 4th floor, directly to the apartment underneath her apartment. And the door opened and she fired shots because she believed that the victim was in her apartment. You see a picture of them there. Poor guy, innocent guy, doing absolutely nothing wrong, and shot and killed by the officer who thought that he was in her apartment. Guys, this is going to be an unbelievable case legally, and we can't have anything better than the professor. And now, included on that, is the great legal analyst here at the Law and Crime Network, Jean Rossi, 30 years at the DOJ. He's trained over 1,000 prosecutors. Welcome to the show, Jean.
Good afternoon. Thanks for having me.
Good afternoon, Jean. Just to put you up to speed, because you were a little tardy today, myself and the professor have already gone over what the indictment is with regard to murder with intentional, knowing, reckless, and criminal negligence there in Texas. And they have a lot of varying language. And it's very, very important that our baby prosecutors and our defense lawyers know what the law is that the jury is going to hear at the end of the day, because it's not about what you feel. It's not about protests in the street because you feel that the officer did anything wrong. It is about this police officer entitled to proof beyond a reasonable doubt with a presumption of innocence, and whether they can prove those elements of those offenses, as we call elements, ingredients, like baking a cake, beyond a reasonable doubt. But Jean Rossi, as you know, there are not just the law, but there's also in the criminal world affirmative defenses. So I'm not going to hit you with a heavy one right now, because I know the professor is actually in the process of teaching his law students some of that. Now, the ones that I see, we'll deal with the more difficult one in a minute, which is self-defense. But the one that popped right out to me from the beginning is mistake of fact. Okay, now this is what an affirmative defense is. What an affirmative defense means is that even if you did everything the prosecutor said and they prove it to you beyond a reasonable doubt, if it can be proven that this affirmative defense exists, like self-defense, that's the one most people know, then it results in a not guilty verdict outright. So, Professor, you talked and brought it up also about mistake of fact, section 802 out there in Texas, where it is, ladies and gentlemen of the jury, it is a defense to a prosecution that the actor, through a mistake, formed a reasonable belief about a matter of fact if his mistaken belief negated the kind of culpability required for the commission of the offense. And I just want to add to that, because we want to be thorough, although an actor's mistake of fact may constitute a defense to the offense charged, he may nevertheless be convicted of a lesser included offense of which he would be guilty if the fact were as he believed. A little complex, and I always feel this sometimes when I'm trying a case, whether it's a prosecutor, defense lawyer, the jury has read these jury charges, and sometimes I wonder, like, how, I've been doing this for 30 years, how are they getting it? But can you break that down in layman's logic, parlance as to what a mistake of fact as an affirmative defense is?
Sure. So first of all, just, I'll get back to it. That term reasonable, that's where we earn our keep as lawyers. So, it means that the defendant had a mistaken belief of the circumstances as they were. So, in short, you walk up to me, you're approaching me to ask me what time it is, and for whatever reason, I think that you're going to attack me, and I defend myself. That's a mistake of fact. Now, is it reasonable that when you approach me in the street to ask me what time it was, I should think that you were going to attack me? Not necessarily. And that's what's the question here for the jury.
Yeah, I agree completely with the professor. Jean, with regard to the word reasonableness here, what are your thoughts? I mean, clearly the defense is going to say she wound up at the wrong apartment. We'll have to wait to figure out what that is. I don't believe there's going to be any indication of drugs or alcohol here, because she had just gotten done with her shift, but we'll have to await those facts as well. She made a mistake and went to the wrong apartment. I get it. It's odd, it's peculiar, it's weird. But if the jury were to believe that she believed at the time she went into her apartment that there was a person inside of her dwelling, could that raise a potential affirmative defense of mistake of fact?
Yes, and if they find that she actually thought reasonably she was in her own apartment, then there will be a hung jury or an acquittal. This is an egregious case. And I want to go back to what you said, Bob, about trial notebooks. I totally agree. The first two tabs in your trial notebook should be the indictment, of course, and the second should be the jury instructions. Because when I used to present cases to the grand jury and supervise my baby prosecutors, they always read the elements of the crime to the grand jury before they went into the room alone and deliberated. So those two documents are absolutely crucial. And I think if they find that it was reasonable for her to think she's in her own apartment, then it was reasonable for her to think that that was a burglar who could cause serious bodily injury or death to her. As tragic as these facts are.
Yeah, and Professor, it kind of getting back to what I was saying before, and Jean said as tragic as these facts are, and it is tragic, is by all estimations, a beautiful guy, doing the right thing, was in his own place, minding his own business, and he's shot and killed. But getting back to the point that I was making before, there is a difference between criminal culpability, criminal responsibility, and an accident.
Oh, absolutely. And that's why, theoretically, why we have affirmative defenses and these types of defenses under the law. Because as heinous as they may be, accidents do happen. Bad things happen to good people, and it's no one's fault. And it's all about whether the defendant is blameworthy, whether they should incur criminal liability or not. And that's what this case is going to turn on. Just wanted to raise another point. I think her background and whether that will whether that's something the jury will be able to consider will be wildly important. Will she be considered under a reasonable person standard or under a reasonable police officer standard? Two wildly different things.
Right, right. Excellent points. And let's just make sure our audience understands that this trial is about to get underway. There's going to be opening statements. There was a motion for a mistrial that was made by the defense. And guys, let's just take a little sidebar here, because we have the ability to be able to do that here at the Law and Crime Network. We can take our sidebars this week. That's the power of the host position. Man, Jean, I'm going to go to you because you have extensive experience as a prosecutor, and I, who led an agency for many years. The last thing I'm doing as the district attorney, in any case, I didn't do it, period, but especially the day or the couple days before the trial, is start making public statements about the case, especially when there's been a motion for change of venue. And this violated a gag order of the judge and provided the defense attorney with a motion to have this case thrown out. Now, I doubt that that is going to happen, but why is it that these prosecutors can't stop getting behind the mics and talking about cases where they're supposed to be tried in the court of law, not the court of public opinion? Rossi.
I think, I got to tell you, that motion for mistrial, that had legs. Because right before trial, in light of a gag order and a change of venue, I got to say this on television, that was reckless, it was premeditated, and it was disgraceful what he did. But Bob, this is the same state that has the photo of the victim behind the witness box throughout the trial.
Yeah, and it's the same. Yeah, Gene, we can't get that out of our head. That may have been the Magic 8-Ball case. I'm not really sure. But you have that, and you have a state that didn't even require unanimity with the jury when imposing the death penalty until that literally got changed. Really tough territory. But, Professor, I ask you, I mean, the judge has a lot of tools at their disposal how to handle it. If it were me, yours truly, sitting there as a judge, I wouldn't dismiss the indictment because of it. I can certainly dear the jurors to make sure that they didn't hear anything and that they haven't been, poisoned that way. But I'll tell you what, I'd sanction him and consider referring it to the ethics committee.
Certainly, and not to mention the jurors are under extreme pressure here. This is a rather sensational case in that community. I think that's probably part of the reason why the prosecutor felt compelled to go before the cameras, because everybody is asking questions and they want to know where they think this is going. And it's really tough on the jurors. So I would agree with Jean that you really have to, it's irresponsible. You have to be sympathetic to, first and foremost, to the jury.
All right, Gene, I'm going to throw the curveball at you this way as well, because we can go into a lot of different places, because we've been around the block, all of us here. I love having you guys on as guests. This is why I say over and over again, I am in favor of prosecutors appointed by the governor as opposed to elected by the people, because this case was charged as a manslaughter, got upgraded to a murder, and I have to say there was a lot of protest before anybody knew the facts, before anybody knew what occurred here, before anybody listened to the statement of the defendant. They quote unquote wanted justice, and sometimes these elected prosecutors like Michael Nifong and others that I'll let remain nameless wind up letting the tail wag the dog. What do you think, Gene?
Absolutely. I am totally against elected, I'm even against elected judges. It's not a perfect system, but it's better to have appointed prosecutors and judges, number one. And number two, and this is a proposal I put out in the state of Virginia, if you have a murder, a police homicide involving a defendant who's a police officer, like here in the city of Alexandria, I would have that case prosecuted by a prosecutor 150 miles away. And in Virginia, they're elected, but at least you don't have that local political angle that you see in a lot of these cases.
Yeah, it's sad for me to say because I was appointed by the governor in my position, but and still there's a lot of pressure on you. And I would always say to my staff, our job is not to let the tail wag the dog. We got to make decisions. We're going to either make the right ones or wrong ones, but at least we'll make the ones we believe are honorable, and we'll be able to have our head held high. It is so much easier to do. And I don't mean to say all elected district attorneys are bad. Please, that is not my message. But I have just seen too much in politics and prosecution, which I always call, Gene, you've heard me say this, politics and prosecution, a toxic cocktail in terms of criminal justice, yeah, and in terms of justice in general. Guys, I love having my great guests here. Professor and Jean are going to be carrying us through this entire trial. Openings are about to begin. The judge took a little bit break to consider the motion for the mistrial based on the DA's extrajudicial statements, what we call them. And we'll be back shortly.
What would happen if I had to pick up the phone, call 911 for one of my family members or one of my neighbors? What would I do if no one was on the other end to respond? What if there was no 911? So you can be a part of the solution.
Anybody can be a firefighter, male, female, younger, older.
We have school teachers, we have leaders in business.
Is me, you, anyone that wants to be.
There is no typical firefighter.
Everybody can make something because I think everyone has a spark of creativity, and the reason that I have to keep making is because I don't think my life would be as fulfilling without it. If you make things yourself, that means you're not cowering in fear. You're out there taking chances. That, I think, is my way of saying I love you to the world. All right, now I want to hear why you make.
Share your own Why I Make story today. Visit whyimake.org.
Can I give you a hand?
Interstate moving is much more complicated than just moving within your city or town.
Anyone can fall victim to moving fraud.
Do not sign a contract without knowing who you're dealing with.
Do the research on the company that's physically doing your moving.
Do as much diligence as you can and document as well as you can.
Do Better Business Bureau searches. I would Google the company online.
And the best place to find information is through the U.S. Department of Transportation.
Learn how to protect your belongings. Visit protectyourmove.gov.
All across the country, people are coming together to speed up what we can learn about health. The All of Us Research Program is calling on 1 million people to join us as we try to change the future of health. For your family, for future generations, for all of us. Visit joinallofus.org and find out how you can become 1 in a million.
Yes. Oh, hi. I suppose you're wondering what an A-list celebrity like me is doing in a place like this. You must know, I'm saving the world. Oh, hi, Beth. Yep, saving the world again. Did you know that 40% of all the food produced in the United States is thrown away? That means everything that went into that food, the pesticides, the water, the land, was all for nothing. Just look at this perfectly good food thrown in the trash. The pizza with extra Cheerios, these goldfish and Band-Aid tacos. And just look at this perfect trash burger. This pasta dog looks delicious.
You don't have to dumpster dive like Ed Begley Jr. to save the planet. Fight food waste by shopping smart and using what you buy before it gets trashed.
That's way better. Ooh, arugula.
Do your part and find out other world-saving tips at betterthaned.org.
All right, welcome back to the Law and Crime Network. We're really excited to start this trial, the Guyger trial. So we were talking, guys, about the motion made by the defense to dismiss this case because of a violation of a gag order. Now, our producer sent over an article to me, so I'm kind of piecing it together. The Dallas County District Attorney met with the family last week, and it's indicating here he feels their pain and their anxiety as they head into the trial. He maintains this is appropriately a murder case. Quote, I've studied what we have, and I feel comfortable that we're going forward on it, but I don't have any idea how it will wind up. I'm not sure if those are exactly some or all the comments that may have publicly been made, but it stresses emphasizing, guys, talk to me a little bit, Professor. I'll start with you because I think this is right up your alley with your students. Talk to our audience about what an extrajudicial statement is and what the necessity and value of gag orders are by the court and how important they are.
Well, it's all about a fair trial. So the defendant receiving a fair trial, and further that having some integrity in the process. Generally speaking, cases are tried in court, not in the court of public opinion. And once you start presenting evidence and talking to the public about the case, folks start doing research, they start doing all other things, and this gets back to the jury and they form opinions. Like I said, the case should be tried in the courtroom.
Right, based upon the evidence, Gene Rossi, that's presented in that courtroom, and that only. And we have, in this day and age with social media and jurors that are continually going on the internet, has wreaked havoc sometimes all the way through very lengthy trials. I've been involved in months long, and one of the jurors has done something that they're not supposed to do. So talk to me, Gene, about the process that goes on. Would you voir dire these jurors about whether they heard any of these statements? And talk to our audience about the common practice a judge will engage in when they find a violation and that a juror may be compromised, how they go about making a determination as to whether that juror will be thrown off or stay on the jury.
Well, I wouldn't ask the jurors if they heard these comments by this prosecutor, who should, frankly, have kept his mouth shut and probably should be held in contempt for another day. But what judges usually do is if they find through the grapevine or from another juror that, juror number A has read an article about the case or heard something on the news, what they do is they close off the courtroom and they bring out that one specific juror, and during trial they voir dire that juror to see what went into their head, what information did they get. If they didn't get any remarkable information or insignificant, you stop there. But if they did, like they walked into a restaurant and saw a TV screen with, Gene Rossi murder trial or something like that, then they find out, well, how if at all, has that affected you? Can you still be fair and impartial? Does that change your view of the case in any way? And if the answer is no, then the defense attorney can scream all they want, but a judge is probably going to let that person stay. If the judge says, I think this person should go, then you get the pinch hitter, you bring in an alternate. And the alternate will replace the person who's been poisoned.
Yeah, and you know what? It's an unforced error by the prosecution. As a former homicide prosecutor myself for many, many years, even prosecuted a case when I was the boss, homicide case. This is unwanted attention. I don't need this legal muck in the courtroom and the defense attorney making motions, a judge being agitated. I just don't need it. It's such bad politics, and I think that's exactly the reason why it was done in the first place, for their own personal gain and in a court of public opinion, as opposed to what's going on in that courtroom. Guys, let's take a little sidebar here. Listen, this is a cop, Professor. You were a cop. for a long time. So I'm going to make some assumptions here I think are reasonable. She's never been charged or convicted of a crime before. She's led an otherwise law-abiding life. She's been on the force for 4 years. I don't expect or haven't heard anything in the media with regard to any disciplinary record or infraction. There was another shooting that she had been involved with that she was cleared of. I'm not sure whether that's getting in or not, but nevertheless, it seems to me as a defense lawyer now, I'm going to start preparing this case a long time ago before we got the opening statements about putting on a potential defense. But I don't know if I'm going to put it on because this law is so tricky for the prosecution under these facts. Maybe I decide not to. But if I did, character witnesses and potentially the defendant testifying, can you tell us how you would construct your defense case if you should need it at the end of the state's case?
Well, one thing I would want the jury to view my defendant as a person and not necessarily a cop. And the reason is that police officers receive training with use to their firearms, and they're retrained and retrained and retrained. So I'm not crazy about the jury looking at my defendant as someone who's had all this training with regards to how to confront and what to do in a life-threatening situation. But I would prefer to see them treat her as a person.
Okay, and let's not forget, we haven't gotten to self-defense yet, and it makes a big difference here. Stand your ground, king of the castle doctrine, or castle doctrine, whatever they call it. Texas has a stand your ground law. That could make a big difference. Hopefully we'll get to that. Judge is back on the bench. We're live in court.
What else? It's fast, Judge, I promise. I want to offer, for record purposes only, Court's Exhibits 13 through 19. These are a memorialization of the state's adherence to Michael Morton Act.
No objection.
Those are admitted for record purposes, 13 through 19. Is that correct? Court's Exhibits 13 through 19, yes, Your Honor.
Okay. And let me just note for the record, motions and limines that we heard earlier today, your request for them to be sealed, of course, will be sealed. And also let me note for the record that I intend to sequester this jury for the entire pendency of this trial. Yes, Mr. Muller.
May I get the written order you're going to ask for it on the sealing?
Yes.
Yeah, Your Honor.
Yes, sir. Thank you so much.
Thank you, Mike.
Anything else?
I'd like to approach the bench, Your Honor, before you leave. If I could have just 1 minute of your time with Mr. Rogers.
Okay.
That has no bearing on anything at all.
Okay, just for clarity, 12:30, you're going to bring them in, swear them in, arraign the defendant, opening statement.
All right, Gene, so obviously there's no way this judge is not going to go forward with this trial despite the motion that's been made. A record of that has in fact been made. Judge has ordered sequestration. Gene, I don't want to go to the opening statements that are about to begin, and I can't wait to watch them. Judges now left the courtroom, so we have an opportunity. Self-defense is another affirmative defense. For those of you who are viewers that have come back with regard to the Amber Guyger case, we have gone over what intention means, what reckless means, what knowingly means, what criminal negligent homicide means in Texas. And we also talked about affirmative defenses, which negate, even if the prosecution proves beyond a reasonable doubt a murder charge, an affirmative defense negates all of it, and the defendant will be exonerated for that. And the first one we talked about was mistake of fact. And this particular case very well could come into play because she believed, if the jury believes it, that she was within her or going into her house and confronted an intruder that was there. So mistake of fact is definitely an affirmative defense I expect to see. Gene, the other one is self-defense. Talk to our audience about what self-defense is, specifically also about what the stand your ground law means and how it differs from, like, say, for example, New Jersey doesn't have a stand your ground law, but Texas does.
Well, my understanding of stand your ground is it's sort of a variation on self-defense. If you reasonably believe, and that's the key word, reasonably believe the Zimmerman case from several years ago, that an individual is going to harm you or kill you, whether with their hands or with an object, you have the right to take their life, and it's sort of an extension of self-defense. You have the right to protect yourself in the face of a potential serious injury or death. That's just basic common law, statutory law. That's my understanding.
And Professor, the one unique aspect of this case, because I've heard some others talking about it, is that, well, she was supposedly on the outside of what she believed to be her door. The jury believes that. And somehow, we're not really sure yet. There's some factual dispute here as to whether a key fob was used or whether the door was ajar or whether maybe even the victim opened the door. We just don't know yet. The door was open. It wasn't forcible entry. She believed there was an offender that was in there. She shot and killed him. The difference in a state like New Jersey requires that if you have an reasonable ability to retreat without harm, you must avail yourself of that prior to using lethal force. But a stand your ground state says, one additional thing from what Jean said, is that no, you have no affirmative responsibility to retreat. You can stand your ground and defend yourself.
Absolutely. In New York, this is referred to as the castle doctrine. One's home is their castle. So you have a duty to retreat if you can do so with complete safety to yourself and others, unless you are in your home. So in a stand your ground state such as Texas, Florida, there is no duty to retreat, no need to step back. If you are under imminent threat, you may return that imminent threat with deadly physical force.
So Jean, let me ask, I mean, as a defense lawyer, is this how you're preparing your case? You're going on mistake of fact. She thought she was in her apartment. Because she thought she was in her apartment, she thought there was an intruder in there. We have stand your ground. She had no responsibility to retreat. She could stand her ground and confront what she believed to be a deadly situation to her inside of her house, the most protected place you can go. And unfortunately, ladies and gentlemen of the jury, this was a tragic accident, but those affirmative defenses negate everything the prosecution is trying to prove here.
Right. It sounds like from what the professor said is, even if you're in New York, you don't have a duty to retreat if you're in your castle. So whether you're stand your ground or in New York, and I'm from Connecticut, I'm sure they have the same concept. Here's the thing about a case like this. Even though the jury's told the defendant doesn't have a right, does not have to testify, has a Fifth Amendment right, subconsciously that jury is going to expect this officer to take the stand. That's number one. Number two, I don't see how the defense can prove, and I assume it's by preponderance, can prove either stand your ground or self-defense if they don't put on this officer. And third, I think she's going to be a very good witness. I'm just looking at this as a defense attorney. Tragic facts, no doubt about it. 15-hour shift. The apartment was identical in scope. The only difference was she got off on the wrong floor. It was dark. You got some good facts for the defendant.
Well, it'll make it really interesting to see what the prosecution raises. I know that there was a motion made earlier today. I'm not sure if the information's getting out from the jury. I'm sure it will be, because just prior to this, minutes prior to the events themselves, she was sexting her partner, her law enforcement partner, paramour, if you will. So we'll be trying to find out everything that was going on before, during the day. There was apparently a gut-wrenching 911 call with lots of data and information in it. Guys, this is a fascinating case we got here at the Law and Crime Network, and you know if you're here with this Dan Abrams production, it's not just this case, although I love this case. It's multiple trials, gavel-to-gavel coverage. We got to take a break. We'll be right back.
Hey everybody, I'm Jesse Weber, and this is legal news you can use. So we all hit a rough patch at one point or another. There's no shame in admitting that. Many times it concerns money, and maybe you're having trouble staying afloat. So our topic today is, when should you consider filing for bankruptcy? Bankruptcy is for those who can't fulfill their financial obligations and need a do-over. But bankruptcy is reserved for only those extreme situations, and a court is going to look at the following. You've tried but failed to work out a settlement with your creditors. You've turned to consumer credit counseling, but it hasn't resulted in a solution. A court ordered that your wages be seized or garnished to satisfy your debts. You have outstanding medical bills that you just can't pay. You either don't have assets or not enough to pay off your debts, or your savings account, if you have one, is not going to help either. Okay, so you want to declare bankruptcy, but which kind? There are two that apply to individuals. Chapter 7, where your assets that can be sold off by a court will be in order to pay off your debts. This includes clothing, jewelry, artwork, or property. Or Chapter 13. Now, this option is better for people who have a steady income, because here you just reorganize your debts and develop a plan to pay back over time. There are a lot of advantages to filing for bankruptcy. Namely, your creditors will stop coming after you, and in certain cases, you won't have to repay some of your debt at all. But remember, bankruptcy can seriously hurt your credit score, and it doesn't relieve you of having to pay specific debts like alimony, taxes, child support, or mortgage payments. So before you file, consult with an attorney first. For more legal news you can use, go to longcrime.com.
Hi there. You might wonder what a famous Hollywood celebrity like me is doing reading in the dark. Is this some new sort of Hollywood method acting? No, this is quite real.
Did you know that Americans use about 4 times as much energy per year as the global average? We waste energy left and right, despite the fact that the dirty fossil fuels we use to power our energy sources wreak havoc on the natural world and destroys valuable wildlife habitats.
By reading with my solar-powered night vision goggles, I'm saving energy and looking sleek.
You don't have to sit in the dark like Ed Begley Jr. to save the world. Fight climate change by speaking up for cleaner, smarter energy, including rooftop solar.
Oh, that's way better. Oh.
Do your part and find out other world-saving tips at betterthaned.org.
Both my legs were amputated due to an IED. It's when you start to try to get back into like an everyday life. I absolutely felt like I lost some of my purpose. There must be something more. When DAV came into my life, they gave me a new mission. I could still be a productive member of society, could still support a family.
The DAV gave him that sense of structure and purpose again to get his life back together.
Visit DAV.org to learn more about our mission.
In addition to getting ready for this cop case opening statements, which they're going to start at 1:30, so they're on break to then. We're on verdict watching another trial, and we've also got the Todd Mullis case because this is the Law and Crime Network, so they got us peppering around back and forth with lots of cases doing the gavel-to-gavel coverage. That's why I love it, and especially makes it a lot easier when you have somebody like the professor and Jean Rossi here that are helping me along. So Todd Mullis, this is the case where he is accused of killing his wife with a corn rake. I apologize. I think there were a couple of times, Professor, last week I was calling it a corn fork, but I'm a city kid. I'm not used to that terminology. But this was a really fascinating case, and I think there's a lot of tells that went on in this case that were positive for the prosecution. One of those, which is a doozy. If the jury buys it, I'd be very interested. I'm sorry to our chatters. I don't have my computer with me, so I can't chat with you today. But please, I hope you still comment. Always love hearing your opinion. But is this 911 call? Let's take a listen.
Amy. You're told 3. Amy. Okay, so what happened that she's not conscious or breathing? She fell on a fork. I took out a fork on her. It was an old fork sitting in somewhere, and then she was halfway out of the barn. Like, she's calling to get out, and then Tristan yelled, and I ran over there, and she's laying there. And pulled it out of her. I couldn't get her out of the barn. The doors were narrow, and she's not responding. So is she bleeding? I can't tell. When I seen it, she was face down. She did not respond to me. Come on. Sir, do you feel comfortable doing CPR? I can try. I'll try anything. Keep doing the compressions until they can help and take over, okay? Come on, respond. The deputies are almost there.
Now, Todd, here I'm gonna play you the part where you're doing the chest compressions, and I'm just gonna ask that you listen in between the chest compressions, okay? Now, Todd, did you just hear that whisper at the end of that?
Yes.
And what did you whisper?
I couldn't hear it.
Okay, I'm gonna play it again. Todd, do you whisper cheating whore right there?
No.
So you don't remember what you whispered?
No.
Okay, I'm gonna play another clip for you. Do you know what you whispered there?
No.
Did you hear that? So I'm going to play that part one more time. The first clip is 6:53 of that second tape, and this second one is right at 0700. Just try to listen really closely. I just want to know if you remember what you said. Right there, do you say "go to hell, cheating whore"?
No.
So you don't hear that?
No.
You didn't hear at 6:53, cheating whore. You didn't hear that.
I didn't hear that word.
And it's right at that, after you hear a ping, you don't hear "go to hell, cheating whore."
No.
Oh boy, man! I remember when I would open up those homicide files and it may be a whodunit, and some piece of evidence like that comes popping out, and you're like, "Oh my God!" You call the whole gang together, all your detectives, are like, "You will not believe what is on this tape." Now, guys, let's put this into context. The motive here is that the victim, had cheated on him 2 times. The victim had made repeated and numerous statements. We're going to get to that in a minute. To other people that she was in fear of her life and that he would kill her if you found out. This is kind of a remote area. She winds up with a corn rake in her, but he even called it a corn fork, so I'm going to give myself a break. A corn rake in her back. That has 4 prongs, but she had 6 prongs in different directionalities, so that excuse that she fell on it kind of fell on deaf ears from a forensic point of view. There's really not anyone else who had a motive or was around to have done it, but let's go to this statement. Gene Rossi, I will start with you because I hear you going, oh. It clearly is indicating that you can hear it. It's muffled, but cheating whore is what he says, and then the prosecutor cross-examining, he says, "Did you not say go to hell, cheating whore," in another section? So 2 times on that tape. And what I found really interesting is that he can't even tell you, he doesn't say, "I didn't say that, that's not what I said." He can't even tell you what he said, and no one knows his voice better than he knows his own. If I were a prosecutor, I'd be taking that downtown to Chinatown.
Absolutely. And this may be over trying the case, but in rebuttal, I would have an expert on audiology to slow-mo this tape and show to the jury, because you can slow it so you can get those exact words. And there was a movie from a year ago called Blowout with John Travolta, where they had a tape in a murder case, and they slowed it down, and it was just incredible what they can do with these tapes.
Yeah, it is amazing. Professor, I want to ask you a legal question because it's been kind of bothering me about this case. In New Jersey, we have what we call the Machado Doctrine, named after a case. And I was actually involved in something very similar to this in a death penalty case I tried, where essentially it said, statements made that were not subject to cross-examination by a victim of a fear of impending death by a spouse, that happened to be the case I was handling, are inadmissible because it violates the confrontation clause because the defense can't cross-examine the declarant of that statement. And there was also that United States Supreme Court decision, Crawford, now it's got to be 10 or 15 years old, and I did a lot about the wholesale introduction of testimony that can't be cross-examined. In Jersey, that information that she said to multiple people that she was in fear of her life, so I'm pretty confident would have caused a reversal, but it was allowed here. So 1, I'm curious about what your legal opinion about that is, and 2, we kind of have a different system of justice depending on what jurisdiction you're in.
That in and of itself is amazing. It never ceases to amaze me. You can be on trial in New York, New Jersey, Connecticut, Texas, Florida, have different outcomes based on every state. So this is all about the confrontation clause, the right to face your accuser and cross-examine your accuser. And here, obviously, he was unable to exercise that right. And it really depends on, like you said, what state you're in. So there's a lot of information here that was able to get in. He can't cross-examine the witness, what she said, and of course, it's because she's no longer alive. So 2 competing interests there.
Yeah, and so, Gene, we talk about this. I have a very short window, 15 seconds or less, Gene, that just because you can doesn't necessarily mean you should. Thoughts?
Absolutely. I got to tell you, in this case, I would hold back because that could be reversible error or unduly prejudicial. So you're right. You may be able to, but you may not want to for strategic reasons.
Yeah, guys, listen, I really appreciate everything that you guys are doing. Couldn't have a better crew than these guys to cover all these cases. Verdict watch in one case, opening statements on another case, and we are just doing it all over the place here at the Law and Crime Network, a Dan Abrams production, the only place you can find multiple trials, gavel to gavel coverage. We're going to take a very short break, and we'll be back. We've got a lot of action today here at the Law and Crime Network. Stay with us.
Hey everyone, I'm Jesse Weber, and this is more legal news you can use. Today's topic focuses upon the common issue of when your neighbor's trees cause you problems. So what are your rights? By law, you can trim branches or limbs of a neighbor's tree that extends past the property line. But don't go overboard. You can't chop down the tree. Otherwise, you may have to pay for it. Now, if the tree blocks your view, 1, check if there's a local ordinance. 2, maybe you can enter into an agreement with your neighbor regarding the view. Or 3, see whether your neighbor deliberately and maliciously blocked your view, because you then may have a case. A couple more strange things. Your neighbor not only owns the tree, but the fruit on it too. So technically, you're not allowed to pick fruit off of it. Courts, however, are split about fruit that falls onto your property. Although, honestly, why not just go to a supermarket? Are you really that in need of an apple? Also, you may think your neighbor has to clean up all the leaves from the tree that blow into your yard. Well, you'd be wrong. Leaves are not the owner's responsibility, so instead, try building a fence. Now, your neighbor can be held liable by a court if a tree falls and causes damage to your property, but it all depends on how the tree was maintained and inspected. At the end of the day, it's important to know your rights, but always try speaking with your neighbor first to address the problem. Go to lawandcrime.com for more legal news you can use.
A brain aneurysm doesn't care if you're busy. It doesn't care that you have important meetings. It doesn't care that you have to drop your daughter off at ballet and your son off at soccer practice. And if you ignore the warning signs of a brain aneurysm, you'll realize too late that the meeting wasn't that important. No meeting is. That you'll never see another soccer game, and that your daughter won't see you in the audience at the big recital. So if you suddenly experience the worst headache of your life, sharp pain behind your eye, and blurry vision, don't ignore it. Seek immediate emergency care, because your family is counting on you to take care of you. The Lisa Calagrassi Foundation, shedding light on brain aneurysms. Learn more at lisafoundation.org.
As we constantly talk about privacy today, one of the biggest questions is how do you protect a photo or video of yourself from being used online without your permission? Now, I know you kids love face twittering and instabooking, so let's start with the basic idea that you need to be careful where you post pictures and videos. That means understanding a website's terms of service, because you may be granting a site a license to use your image in ways that you weren't aware of. Also, most legitimate sites will lay out their process to remove material, so you'll want to follow those steps first to get something deleted immediately. But what laws help you to do all this? Here we go, you little legal eagles. Basic rule: you automatically own the copyright in any photo or video you take. Technically, you can go after someone for copyright infringement if your photos or videos are posted or distributed online without your permission. However, under a complicated law called the DMCA, platforms that allow people to post on their sites, such as YouTube, must be provided notice of the infringement before you can properly sue them. Speaking of lawsuits, you may be able to sue someone under state right of privacy or publicity laws. For example, if without your consent your face or body are being exploited online to sell or promote something, or if there was a photo or video secretly taken of you while you were in private, you may have a very strong case. Go to lawandcrime.com for more legal news you can use.
Do you know the signs of a brain aneurysm? The worst headache of your life? Pain behind one eye? Dizziness or blurry vision? Don't ignore it. Seek immediate emergency care. The Lisa Calagrassi Foundation. Learn more at lisafoundation.org.